An Introduction to the Constitution and Republic Review. What is the Constitution? Some teach it's a living document to be interpreted for the current times. Others teach it as a noble guide for governance carved into stone with strict amending instructions. The simple fact: the Constitution is a compact, in other words, a contract, written for and by the states which created the federal government. Is there proof of this? Of course there is. Thomas Jefferson, James Madison, as well as all the framers referred to the Constitution as a compact and a contract. In addition, Article 7 required that 9 of the original 13 states had to ratify or buy into this new form of government to make it legitimate. The Constitution then became the supreme law of the land and created the general government. So what does ratify mean? It means the same today as it did in 1787. Ratification is the formal process of accepting a contract, compact, or treaty. Article 7 of the Constitution also identifies the stakeholders or the parties to this compact who possess the authority over and oversight of this compact. Those who possess the oversight authority are the states. This oversight authority is also supported by Article 5. Before any changes can be made to the Constitution or this compact, 3/4 of the states need to ratify, in other words, accept the change to the Constitution. Keep in mind, the ratification process of the Constitution was not a binary vote of yes or no. Delegates were chosen to ratify the Constitution in a convention who read and thoroughly debated its substance and meaning line by line. In fact, these debates actually clarified the terms of the compact in a sundry of ways, thus making these definitions and clarifications legally binding in accordance with contract law. To be clear, the Constitution was and is today an enumerated constitution, not a general constitution. An enumerated constitution means that only specific powers are delegated to the general government, which are listed in the compact. Just like any contract, a general constitution is similar to a general power of attorney. General powers are delegated to the government. It is left to the government's discretion as to what powers they choose to exercise. This is not the United States Constitution. To support this concept, all of the original states, immediately after ratifying the Constitution, submitted amendments they wanted added to the Constitution. Madison's first order of business in the new Congress was to create a Bill of Rights. As Madison wrote in the preamble to the Bill of Rights, the convention of a number of states having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending to the ground of public confidence in the government will best ensure the beneficent ends of its institution. The two amendments that all states demanded were the 9th and 10th Amendments. The 9th Amendment ensured that the rights of the people could not be denied by the enumerated powers in the Constitution, and the 10th Amendment pointed out that all powers not delegated to this new general government are reserved to the states and the people. When a minor deviation in the Constitution was desired, the only mechanism to change a process, role, responsibility, or power of the general government was to follow Article 5 of the Constitution. Article 5 spells out exactly how the Constitution may be amended. The framers not only amended the Constitution with the Bill of Rights, but they also amended the Constitution to add clarification to judicial powers in the 11th Amendment. They also amended the Constitution to make a minor change to the Electoral College and process of choosing the president. These 12 amendments set precedents that statutes and regulations could not be used to make minor changes. We are not following this process today because in the mid-1800s, the general government decided they no longer had to follow the Article 5 process. This is why we no longer follow the Constitution process in choosing our president and vice president. There is no allowance for people voting for the president directly, primaries to eliminate candidates, and no allowance for the winner of the popular vote in a state to take all of the electors. To be crystal clear, the Constitution makes no allowance for the general government to change a defined process in the Constitution by using statute and regulation, such as the choosing of the president. Consequently, the process used today for choosing the president and vice president is not in concert with the Constitution. The process used today are misconstructions and violations of the Constitution, and this is only the tip of the iceberg. President George Washington, in his farewell address, stated, "If in the opinion of the people the distribution or modification of the constitutional powers be in any particular wrong, let it be corrected by an amendment in the way which the Constitution designates. But let there be no change by usurpation, for though this, in one instance, may be the instrument of good, it is the customary weapon by which free governments are destroyed." After the framers all died, the following executive departments were created without amending the Constitution in accordance to Article 5. Interior, 1849. Justice, 1870. Agriculture, 1889. Commerce, 1903. Labor, 1913. Health and Human Services, 1953. Housing and Urban Development, 1965. Transportation, 1966. Energy, 1977. Education, 1979. Veterans Affairs, 1989. Homeland and Security, 2003. These are not the only usurpations elected servants and the unelected deep state have developed in subverting the Constitution, but these serve as an example of the many powers that the general government is exercising without the states formally delegating the power to the general government in an amendment. So what do the shareholders of a compact do when their compact or contract is being violated? Most would say you go to court. No. There is no court in the world that has jurisdiction over things not delegated, in this case, matters not delegated to the general government. As James Madison stated in his report on the Virginia resolutions in regards to the general government's violations to the Constitution, no tribunal is superior to the authority of the parties. The parties themselves must be the rightful judges in the last resort. The parties to the Constitution are the states. Thus, the only court possessing jurisdiction is the collective states, who must serve as both judge and jury to remedy the breaches in their compact. This process is referred to as republic review. Republic review is the process where the states collectively audit the general government's exercised roles, responsibilities, and powers, or RRPs, against those RRPs enumerated in the Constitution. All RRPs that are identified as violations must be disbanded and dissolved.